Hi everyone, welcome back. Today we are going to discuss about banker-customer relationship. Introduction. Basically, the relationship between banker and customer is contractual in nature. Since bank offers variety of services to the customer, the relationship between the bank and the customer vary according to the type of service rendered by the bank. The basic relationship between banker and customer has been that of a debtor and creditor. But as the banking service evolved, the relationship too evolved to include special and fiduciary relationship. So, the first initial stage, the general relationship, is that of a debtor and a creditor. Then by evolution came in special relationship, and that can be guarantor, guardian, etc. Then other relationships also include trustee beneficiary relationship, bailor bailee, principal agent, pledgee, lessee relationships, etc. Now, there is also fiduciary relationship that includes right of lien, right of set off, right of appropriation, right to charge interest and incidental expenses. Now, what do you mean by fiduciary relationship? Sir Lord Millet in Bristol versus West Building Society versus Matthew. In the case Bristol and West Building Society versus Matthew, Lord Millet explained fiduciary relationship as a fiduciary is someone who has undertaken to act for and on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. Fiduciary duties in a financial sense exist to ensure that those who manage other people's money act in their beneficiaries' interest rather than serving their own interest. Fiduciary relationship is built on the basis of trust, and that is the basic ingredient forming the platform on which the banker-customer relationship is based upon. Now, the definition of the term customer is not satisfactorily given in the Act. Similarly, there is no satisfactory definition of the term banker either. However, many philosophers have tried to provide a reasonable definition to the term. Now, if the customer had employed the bank in a fiduciary capacity, the customer is entitled to a proper charge on balances held by the bank as a whole on the date of suspension of the payment. So, if the customer had employed the bank in a fiduciary capacity, the customer is entitled to a proper charge on balances held by the bank as a whole on the date of suspension of payment. When a person dealing with a bank delivers money to the bank, the intention to create a creditor-debtor relationship is presumed unless rebutted. In UCO Bank versus Hemchandra Sarkar 1990, UCO Bank versus Hemchandra Sarkar 1990, the plaintiff opened an account in a bank for the purpose of his business of lifting goods from mills. The bank performed the services of collecting bills, making remittance to the mills, meeting expense of sorting the goods in the bank's godown, and debiting the same to the current account of the plaintiff, even without taking any check from him. The lower court and the high court held that no fiduciary relationship existed between the parties. The bank acted as a bailee and not as an agent of the plaintiff, whereas Honorable Supreme Court held that the banker constituted himself and acted as an express trustee or as an agent of the respondent in relation to the said goods and documents, and thus stood in fiduciary relationship. So that was held in UCO Bank versus Hemchandra Sarkar 1990. In Hong Kong Bank of Canada versus Phillips 1998, Hong Kong Bank of Canada versus Phillips, it was held that the bank, having knowledge of fraudulent misrepresentation, induced the customer to invest in a worthless transaction. That was held it is a breach of fiduciary duty on the part of the bank, as stopped from pursuing the customer. So the same view was also taken in Ans versus Merton London Borough Council in 1978. So, in Hong Kong Bank of Canada versus Phillips, it was held that the bank, having knowledge of fraudulent misrepresentation, induces the customer to invest in a worthless transaction. It was held that it is a breach of fiduciary duty on the part of the bank, stopped from pursuing the customer. The same view was also taken in Ans vs. Merton Lenton Borough Council, 1978. Now, existence of legal relationship. Since banker-customer relationship predominantly encompasses financial matters, it is important to create a relationship with all the legalities in order to safeguard the interest of both the parties involved. Usually, the legal aspect cover the process in which the customer deposits the money and the banker pays the money so deposited by the customer, with an exception of loan. Establishing legal relationship is equally important to safeguard the rights of the parties and also to establish a foolproof working model to ensure that public at large follows the model without any discrepancies. Now, some of the acts passed by the Parliament to safeguard this relationship are: 1. The RBI Act of 1934. It was enacted to establish RBI as the banking regulator to spell out the parameters within which banks should operate. It also lays down ground rules for the working process of banks and its officers. 2. The founding pillar was the nationalization of banks in 1969, which paved the way for several other legal frameworks to safeguard the rights of bankers and customers. 3. The Securities Exchange Board of India, that is SEBI, established in 1992, also put certain restrictions on the bankers alongside providing them with reasonable powers. The fourth one, the Consumer Protection Act of 2019, is one such act which protects the rights of customers. Since a banker can be considered as a service provider, their relationship is covered under Consumer Protection Act. And the fifth one, the SARFAESI Act, was passed in 2002 with an objective to provide security to the banking institutions and their assets. And the sixth one, Debt Recovery Tribunals, DRT. The DRTs were set up under SARFAESI Act by way of amendment in the year 2016. So SARFAESI Act was enacted in 2002 and DRT was set up under SARFAESI Act by way of amendment in the year 2016. Now, when we consider the banker-customer relationship, we should understand the various kinds of relationship, from general principles to special relationship, other relationship, as well as fiduciary relationship. So the first category is debtor and creditor relationship. The first feature of banking is to accept deposit and lend money. The banker accepts money from customer in the form of deposits and lends or invests the same. The deposit is repaid on demand from customer as per the agreed terms. The money so deposited is a loan given by the customer to the bank, and hence customer assumes the position of a creditor and bank as debtor. The relationship reverses when bank lends money. In this case, the customer becomes debtor and bank becomes the creditor. Starting with this, in commercial parlance, the banker-customer relationship has other aspects. Now, what are these other aspects? So, four kind of scenarios are given. The first one, generally, the debtor repays the money without any demand, but in banking parlance, the customer has to demand his money by way of check, or otherwise the banker is not obliged to repay the money without a specific demand. This is due to the fact that a banker is not an ordinary debtor. He accepts the deposits with an additional obligation to honor customer's check. If the banker returns the deposited money on his own account by closing the account, some of the checks issued by the customer might be dishonored, tarnishing the image. Moreover, according to the statutory definition of banking, the deposits are repayable on demand or otherwise. The depositor makes the deposit for his convenience, apart from his motives to earn an income, except the current account. Demand by the creditor is therefore essential for the refund of the deposited money. Thus, the deposit made by a customer with his banker differs substantially from an ordinary debt. However, in case of term deposit, the bank should inform the maturity of the deposit to the customer. Now, the second scenario is that another critical factor of the special type of debtor-creditor relationship is that the creditor must demand the payment at the right time and right place. The depositor or creditor must demand payment at the branch where he has opened the account. However, with core banking services, the customer can demand payment at any branch of the concerned bank, and the demand can also be made through automated teller machine, that is the ATMs. Hence, demand should be either in traditional manner at the designated branches or at ATMs. Also, some banks allow payment at all their branches and ATM centers. In conventional banking, even the concept of making a demand at right time was important. The right time in those days implied that the demand must be made by the customer on a working day during working hours of the bank. The Negotiable Instruments Act specifies the term holidays and days which are not holidays. However, with introduction of debit cards and ATMs working round the clock, the concept of demand at right time is diluted. Further, demand can be in the form of check, withdrawal slip, e-banking, telebanking, or the like. Now, the third scenario, if the banker makes payment before or after the working hours, he can be held liable. Meantime, if the customer countermands the payment of the check, banker cannot debit his account. The position will be same if garnishee order is served on the banker restraining him from making payments. Now, the fourth situation is that death or insolvency of the customer will also make payment of check invalid. So, as we have discussed, the banker is a privileged debtor. And how is that? So, let's see that. The money received by a banker is at his free disposal. The banker may retain or invest or lend to another customer. The customer has a right only to the extent of demanding amount by way of check payable to customer himself or to his order. For the first time in Foley versus Hill, that is Foley versus Hill, it was held that there exists a quasi-legal relationship between banker and customer. As the modern form of banking evolved, this relationship became quite inadequate and hence a principal-agent relationship was tagged. An agent holding money for principal is under strict obligation to meticulously account for its use. This is impossible in banking in the current scenario. Thus, the decision in Foley versus Hill rejected that banker-customer relationship as that of agency. So that was discussed in Foley versus Hill and with respect to banker as a privileged debtor. Now, relationship of trustee and beneficiary. As per Indian Trust Act, a trustee holds money or assets and performs certain function for the benefit of some other called the beneficiary. The position of a banker as a trustee or as a debtor is determined according to the circumstances of each case. The relationship between the banker and his customer as a trustee and beneficiary depend upon the specific instruction given by the latter to the former regarding the purpose of use of the money or documents entrusted to the banker. When a banker accepts items like securities or documents for safe custody or maintains escrow accounts of the customer, the relation between the banker and customer is a trustee and the beneficiary. The bank is the trustee and the customer is the beneficiary. The customer is the beneficiary, so the ownership remains with the customer. The relationship between the banker and his customer as a trustee and beneficiary depends upon the specific instructions given by the latter to the former regarding the purpose of use of the money or documents entrusted to the banker. In New Bank of India Limited versus Pyari Lal. In New Bank of India Limited versus Pyari Lal, 1962. The Supreme Court in this case observed that in the absence of other evidence, a person paying into a bank, whether he is a constituent of the bank or not, may be presumed to have paid the money to be held as banker ordinarily held the money of their constituent. If no specific instruction are given at the time of payment or thereafter, and even if the money is held in a suspense account, the bank does not thereby become a trustee for the amount paid. In the case the borrower transfers to the banker certain shares in a company as a collateral security, and the transfer is duly marked in the books of the issuing company, no trust is created in the respect of such shares, and the bank's position remains that of a pledge rather than as a trustee. So that was held in New Bank of India Limited versus Pyari Lal, 1962. Pronouncing the above verdict in New Bank of India versus Union of India, 1981, now the Delhi High Court observed that a trustee is generally not entitled to dispose of or appropriate trust property for his benefit. In present case, the banker was entitled to dispose of the shares and utilize the amount thereof for adjustment to the loan amount if the debtor defaults. The banker's obligation to transfer back the shares can arise only when the debtor clears dues of the bank. When bank is appointed as a receiver by a court in a partition suit between members of a Hindu undivided family, money received by the bank is deposited in current account and the bank acts as trustee for the amount. Now, the next relationship is relationship of a lessor and lessee. According to Section 105 of Transfer of Property Act 1882, the definition of lease, lessor, lessee, premium and rent is as follows. A lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied or in perpetuity in consideration of a price paid or promised or a share of crop service or any other thing of value to be rented periodically or on specified occasion to transferor by the transferee who accepts the transfer on such terms. So this is the definition given as per Section 105 of the Transfer of Property Act 1882. The lessor, lessee and rent are that A. The transferor is called the lessor. B. The transferee is called the lessee. And C. The money, share, service or other thing to be rendered is called the rent. Amongst other services, safe deposit locker is provided by the bank for safekeeping of the valuable items like jewelry and documents. It is not in the form of loan or in the form of deposit. It is a small secured space leased out to the customer. It is similar to renting out space for residence or commercial purpose for annual rent. In this scenario, the customer is termed as lessee and the bank is termed as lessor. In other words, bank is the lessor or the licensor and the hirer of a safe deposit locker is the lessee or the licensee or the tenant. Here the bank enters into an agreement with the customer. This agreement is known as Memorandum of Letting and attracts stamp duty. Bank gives the locker to the consumer on lease. It also leases their immovable property to consumers and gives them the right to enjoy it during the specified period. There is no responsibility of the bank for any damage to the content kept in the locker, as bank is not the insurer. Now, the next relationship is that of a principal and agent. So, we already discussed Frawley versus Hill. Now, here that was under a banker as a privileged debtor. So, that case law is relevant when you are discussing the relationship of principal and agent too. Now, Section 182 of the Indian Contract Act 1872. Section 182 of the Indian Contract Act defines the agent as a person or human being employed to do any act for another or to represent another in dealings with the third persons. The person for whom such act is done or who is so represented is called the principal. Therefore, an agent is a person who acts for and on the behalf of the customer and under the latter's express or implied authority, and the acts done within such authority are binding on this principal, and the principal is liable to the party for the acts of the agent. The bank undertakes various agency works in usual course of business. Vice, it collects checks, drafts, dividends, interest of securities, and pays fees, duties, subscriptions, premium on behalf of the customer as per standard instruction, etc. This relation between the banker and customer is an agent and principal. For doing all these acts as an agent, the bank is entitled to commission. The bank can exercise lien for non-payment. In the matter of Purewal and Associates and another versus Punjab National Bank and others, that is 1993. Purewal and Associates and another versus Punjab National Bank and others, 1993. Where the customer failed to pay dues of the bank, the Honorable Supreme Court held that the bank can exercise lien on the account, and also ordered that the bank shall allow the customer to operate at least one of the current accounts to enable the debtor to carry on its day-to-day business, transaction, etc. And the liberty was given to the bank to institute other proceedings for the recovery of its dues. So that was held in Purewal and Associates and another versus Punjab National Bank and others. That is 1993. Now, relationship of assigner and assignee. An assigner is a person who transfers his security rights to a lender as collateral to the money borrowed by him. To avail loans, sometimes the customer transfers his right on life insurance policies and national savings certificates, etc., in the name of the bank, which results in creation of assigner-assignee relationship. The bank on whose name security rights are transferred by the assigner is called as assignee. Upon clearing the loans, the assigner can demand for reassignment of the securities in his name. So the next relationship we are going to discuss is that of bailor and bailee. Relationship of bailor and bailee. As per section 148 of the Indian Contract Act, bailment means delivery of goods by one person to another for some purpose upon a condition that the goods shall be returned when the purpose is accomplished or otherwise disposed of according to the directions of the person while delivering the goods. The person delivering the goods is known as bailor, and the person to whom goods are delivered is called bailee. So the person delivering the goods is known as bailor, and the person to whom goods are delivered is called bailee. In the case of banker-customer relationship, when a locker is leased to the customer, the contract of bailment is created. Customer is the bailor and the banker is the bailee. The bailor is still the rightful owner of the items deposited in the locker, though the items are in bailee's possession. As a bailee, the bank has to take care of the goods bailed. In addition to the above, relationship of pledger and pledgee is also a type of bailment in which goods are delivered by one person to another as a security for payment of a debt or performance of a promise, and that is discussed under section 172 of the Indian Contract Act. For example, the borrower delivers the gold to the bank as a security for the loan granted by the bank. In this case, the borrower or customer who pledged the gold to the bank is the bailor, or pledger and the bank is the bailee or pledgee. But in this case, goods are given to constitute as security. The next relationship is that of surety and principal debtor. A bank as a guarantor gives guarantee to its customer by issuing a bank guarantee or a letter of credit. It is non-fund based facility to its customer to facilitate trade or business or occupation. This guarantee contains an undertaking to pay the amount mentioned therein without any demur or protest. It is a commercial instrument in the nature of a contract intended between two parties to secure compliance with the contract. Section 126 of the Indian Contract Act defines a contract of guarantee as contract to perform the promise or discharge the liability of a third person in case of his default. So, a contract of guarantee is discussed under Section 126 of Indian Contract Act, and it is a contract to perform the promise or discharge the liability of a third person in case of his default. So that is discussed under Section 126 Indian Contract Act. The person who gives a guarantee is called the surety, and the person on whose behalf the security is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. Further, as per Section 31 of Indian Contract Act, Section 31 of Indian Contract Act, which discuss about contingent contract. Contingent contract is one to do or not to do something if some event collateral to such contract does or does not happen. Banks give guarantee on behalf of their customers and assume the responsibility for customer in case where the customer fails. It would thus be observed that banker-customer relationship is contingent relationship. Now the next kind of relationship is that of an indemnifier and indemnified. The customer is indemnifier and the bank is indemnified. A contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or the conduct of any other person is called a contract of indemnity, and that is discussed in Section 124 of Indian Contract Act. Section 124 of Indian Contract Act discuss about contract of indemnity. In the case of banking, this relationship happens in transaction of issues of duplicate demand draft, fixed deposit receipt, etc. The underlying point in these cases is that either party will compensate the other of any loss arising from the wrong or excess payment. Now the final relationship we are going to discuss here is relationship as a custodian. With banker assuming different roles and offering various products in addition to the conventional banking, it is imperative that the banks also assume the position of a custodian. When a customer avails the services of a banker and opens a demat account, the securities are held by the banker for their customer in the capacity of a custodian. A custodian is a person who acts as a caretaker of something, and by maintaining the securities for the customer, banker acts as a custodian. So let's discuss about some of the commonly used banker service. So the first one will be deposit in bank. In such a case, the bank becomes the debtor, customer becomes creditor. So in deposit of bank, bank becomes debtor, customer becomes creditor. Then loan from bank. In this case, bank becomes creditor and customer becomes debtor. So with respect to loan from bank, bank becomes creditor and customer becomes debtor. Then we have safe custody. So in safe custody, the banker becomes bailee and customer becomes bailer. In safe custody, banker becomes bailee and customer becomes bailer. And locker, while a customer is using a locker, the bank becomes the lessor and the customer becomes lessee. So these are some of the general transactions we use very commonly. And we have some more, that is collection of check. With respect to collection of check, the bank becomes the agent and the customer becomes the principal. Now, purchase of draft. Here the bank is the debtor and customer is the creditor, that is purchase of a draft. Now, payee of a draft. In that case, the bank is a trustee and customer beneficiary. So when it is with respect to payee of a draft, the bank is the trustee and customer is the beneficiary. Now, pledge. Now here bank becomes the pawnee or pledgee and the customer becomes pawner or pledger. So with respect to pledge, banker becomes pawnee or pledgee and customer becomes pawner or pledger. Mortgage. Here bank becomes the mortgagee and customer becomes the mortgager. Now standing instructions. So here bank becomes agent and customer becomes principal. Now sale or purchase of securities on behalf of a customer. So here bank becomes agent and customer becomes principal. Now money deposited but instructions not given for its disposal. So in that case the bank is the trustee and customer is beneficiary. That is, money is deposited but instructions not given for its disposal. In that case, bank is the trustee and customer is the beneficiary. Articles left by mistake. In that case, bank is trustee and customer is beneficiary. Now, shares given for sale. In that case, bank is the agent and customer is the principal. And then we have hypothecation. In hypothecation, the bank becomes the hypothecatee and the customer becomes hypothecator. In hypothecation, the bank becomes hypothecatee and the customer becomes hypothecator. So that is with the end of this session. Thank you for your support and thank you for listening. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update when I upload my next video or a podcast. Thank you everyone and have a nice day.